A police officer, is found dead on the front lawn, and no one secures the scene. No tape, no preservation of evidence, no crime scene log, no search warrants. Let's not forget, this was Brian Albert's house, and that comes with privileges.
They're not like you and me. They get special treatment. They get special privileges.
These are dog bites and scratches. These are animal wounds. Not one witness has been called in their trial to actually dispute that John O'Keefe's arm injuries are from a dog. Why is there no blood, no skin, no tissue on a single shard of taillight that they claim came in contact with John's arm?
Well, hello everybody, and welcome back to Buckle Up. It's the Law with Attorney Larry Forman. Folks, don't forget to hit that like button, subscribe to the channel if you haven't already, and I will continue Alan Jackson's closing. This is part 2 of 4 in the Karen Reed case. Let's go, folks. Oh, and before I forget, if you have not checked out our members-only content, go check it out. Membership started 99 cents for an intern, and so you can check out all of the content that we have under the paywall, and most of it is going to be Diddy at this juncture.
John didn't even have a bruise. Make no mistake, Dr. Scortibello was presented with the Commonwealth's theory of the case, the same case that you've been presented with, and she refused to conclude that John's death was a homicide. She flatly refused to conclude that there was a collision. And you know who agrees with that? That silent witness. The science, the physics, the data. Dr. Wolf and Dr. Rentschler, you just met them recently. They explained they were not initially hired by the defense. They were asked by another agency to conduct their analysis. They looked at the evidence from both sides, not taking a side for the defense or the Commonwealth, completely independent. They looked at the damage to the SUV on the one side of the coin. They looked at the injuries to John O'Keefe on the other side of the coin. Both PhDs, both engineers determined there was no collision. I'm not saying it. The science says it.
Right.
That SUV's taillight was not damaged by striking an arm, and John was not struck by a 6,000-pound SUV. Period. Full stop. Dr. Dan Wolf did the testing on the taillight. Actual testing, not some ridiculous blue paint kindergarten project. He did lab testing. He did field testing. He did data testing. Actual impact force analyses. In every single test at every single speed, the taillight damage was inconsistent with striking an arm. In every test, the taillight damage was inconsistent with damaging the shirt, the sweatshirt. Remember that severe internal damage to Karen Reed's taillight. Not just the outer lens. The internal diffusers were completely smashed,
huge.
Completely shattered. ARCA testing established that all the internal components of every single test taillight, especially the diffusers, remained completely intact.
Remained completely intact at 29 miles an hour. They remained intact, and yet here, gone. How is that even possible? Oh, if somebody came in and plucked it away. Oh, silly me.
Conversely, on Karen's taillight, the diffusers were almost completely gone. Folks, understand something. If any part of that diffuser portion of the taillight is broken, there is no light. It doesn't illuminate at all. It's just black. Let's take a look at a couple of photos. At 5:07 a.m. at One Meadows, that's the photograph on the left. What do you notice about the right taillight? It's completely illuminated. Later, at 4:12 in the afternoon, photograph on the right, it's lit up. How can that be? How can that be if the Commonwealth claims that those diffusers, the portion that lights up the light, were already scattered all over 34 Fairview? That's their theory. But don't believe your lying eyes. The taillight's completely lit up. That would be impossible.
Yep.
Dr. Andrew Rentschler, a PhD, a biomechanist, explained that at those speeds, the other side of that coin, John's arm would be basically destroyed. Contusions, swelling, torn ligaments, hyperextensions, dislocation of joints and bones, fractured, broken, and shattered. But as you know, John's arm was pristine, save those dog and claw bites. He didn't even have a bruise. Think about this. Think about that photo of those x-rays.
That's
as you deliberate.
huge. That is
You
insane.
can manipulate a taillight fragment. That's not that hard.
Nothing.
You can't manipulate a bruise.
No.
They
They
claim the car
didn't
was-
do this in the first trial, and I don't know why, but this is so impactful. So powerful.
It was going fast enough to shatter the taillight and shatter the diffusers, that it was also going fast enough to destroy
diffusers!
and shatter John's arm,
And his
it
arm?
simply did not.
Nope.
How do they square
Totally
that?
fine.
They don't, and they can't.
Yep.
So they spent nearly $400,000 of taxpayer money to hire someone to dress up and look like John and paint his arm blue.
I know. Kindergarten
Which
project.
told you exactly nothing.
Nothing.
The ARCA testing, conversely, also established that it is impossible for John's sweatshirt sleeve to be damaged by an impact with the taillight. The Commonwealth's theory is that the sleeve of John's hoodie sweatshirt was damaged by flying shards of taillight slicing through the shirt and through John's arm. I have 3 questions. Number 1, John's arm had about 36 abrasions. How did 36 shards of acrylic go through 9 tiny little puncture holes? How'd that happen? Somebody needs to answer that. Number 2, why are there no slices or cuts in the hoodie? All the defects are punctures. Punctures that you might get from, say, I don't know, canine teeth. And number 3, if the shards cut bloody gouges into John's arm, that's their theory, why is there no blood, no skin, no tissue on a single shard of taillight that they claim came in contact with John's arm? The Commonwealth cannot answer a single one of those questions because John's arm was not impacted by the taillight. It doesn't make sense simply because it didn't happen.
It didn't happen.
Compare and contrast the ARCA experts and their actual testing to Judd Welcher. He came to you in the Commonwealth's case in chief, and he told you that for the better part of $500,000, he'd come in and testify that John was tall enough to touch the taillight with his elbow. That's it. And even in that basic demonstration, he had to lean in
Yeah.
to manipulate it
Oh,
to get the
God.
results that he wanted.
Oh, God.
Dr. Welcher then claimed that the reason he didn't do the reconstruction, the actual testing, think about what he said. There isn't enough evidence to determine what happened. I beg your pardon?
I love
What happened?
his genuine shock. Like, there's not enough evidence to figure out what happened. I'm sorry. What did you just say? You're the expert hired by the government to further their theory of the case. I don't know what happened. I wasn't there. What do you want from me, man? I'm just a hired gun. Liar for hire. If you give me $500,000, Jackson, I'll say what you want me to say. Like, you know what I mean? Like, money talks, Welcher talks.
When there isn't enough evidence, in his words. You vote not guilty. That's what happens. That's out of his mouth, not mine.
Mm-hmm.
The Commonwealth also used the same company, Aperture, to try to establish a time of a collision that never occurred. The Commonwealth called Shannon Burgess, the supposed expert from Aperture.
Suppose
There is a cardinal sin for experts, folks. A cardinal sin. It's called confirmation bias. It's when you decide to change your opinion to fit a theory. The most important takeaway from Shannon Burgess' testimony was how brazen, how shameless he was in trying to change the data to try to suit the Commonwealth. Remember Mr. Brennan's opening statement. He made some promises to you. He said, this case is about the data. He stressed it over and over again. They've had 3.5 years to get this right. The Commonwealth has had this case for 3.5 years to get it right. So his top expert, Dr. Welcher, prepares a report. And that report says that John O'Keefe was struck by Karen Reed's SUV at 12:31:38. Note that time, 12:31:38. He was struck, he was immediately incapacitated, he was immediately unconscious. So says Judd Welcher and the Commonwealth's theory. But there was a huge, huge problem with that.
What a blunder.
And somewhere in the middle of trial, somebody must have realized it.
Oops.
They must have realized that the very data they produced unequivocally establishes that they are wrong about a collision. It could not have happened. Why? Because John was interacting with his phone after 12:31:38. Remember, the collision immediately incapacitating. How could he be interacting with his phone afterward? He was on his phone, opening his phone, checking his phone, reading texts on his phone, and locking his phone, all of it after 12:31:38, which is the time Welcher clocked for the moment of the impact. And he was taking steps and walking with that phone after 12:31:38 also. That's what their own data showed, and it devastated their case, and it devastated that false theory. There must have been panic, I'm guessing, in the room. What do we do now? The data shows John wasn't struck by the car. What do we do?
I love how he paints the picture. Like, they're panicking, like, oh my God, our theory just went out the window. What are we going to do? It's amazing. I love it.
Shannon Burgess.
Enter.
Question.
Shannon
Can you believe him? Can you believe Mr. Burgess? He came up with a brand new story right in the middle of trial. You might ask yourself, would an expert actually say something he knows not to be true? Would an expert
For the right
actually
price.
say something he knows is not supported by fact? Would an expert shade the truth?
For the right price. $500,000.
You don't have to look any further than Shannon Burgess's CV to answer that question.
Yep.
That was a shame.
That was a shame.
Even with the pull and push and stretch and manipulation of the time data that Mr. Burgess came in here and told you about, it still shows that John O'Keefe was very much alive and walking around after they claim he was hit and incapacitated. Think about that. Matt DeSogra looked at Burgess's report and told you that in 30 out of 30 scenarios of the possible time skews that Shannon Burgess identified, he came in the middle of trial and identified all these other time skews that he called it. In every single scenario, John was alive and walking after they said he was hit. And that's a problem for them.
Yep.
Because there was no collision. Just look at Mr. Whiffin's data, Ian Whiffin. John O'Keefe took 31 steps at a steady rate, about 83 feet, and then think about this, in a westerly direction. That would be right toward
The house.
Remember, it's 78 feet to that garage door. That's not a coincidence. The Commonwealth's witnesses, or the Commonwealth's witness, Mr. Ian Whiffin himself conceded that he has reasonable doubts about the accuracy of John's location.
I remember that.
Remember that question and answer?
Unbelievable.
Cross-examination by Mr. Alessi. Do you have doubts?
Yeah.
I do. Are those doubts reasonable? They are. And remember, it's still the Commonwealth's burden.
Yep.
If their own cell phone expert has a reasonable doubt about John's location, so should you.
Yep.
John O'Keefe was inside, and the phone battery temperature further proves it.
Oh,
This is
yeah.
not speculation.
This is so
science,
big.
and it's irrefutable. It tells us
Listen.
that he was not laying outside in the cold. He was inside somewhere a little bit warmer. Ian Whiffin told you that when the iPhone is exposed to freezing temperatures, think about these.
And again, that's their expert. He is flipping another one in closing. He's showing them how they flipped it, the expert, during the trial. Unbelievable stuff. Scortabello, Whiffin, Welcher, Burgess. Notice how he focused on a couple of witnesses for the defense so far. Wolf and Rentschler, of course, because they're the biggest. He's showing how their own witnesses are proving the defense's theory.
Numbers.
Almost
when the
never
iPhone
seen
is
it before.
exposed to freezing temperatures, it will drop from 81 to 21 degrees
Not to this extent. Usually you flip like one or two. Not every single one.
in 15 minutes.
Like here.
15 minutes. That's a 60-degree drop in 15 minutes. Now look at John's phone. It was laying, according to the Commonwealth, it was laying directly on frozen ground. He arrived at 34 Fairview and his phone dropped only 20 degrees over the course of an hour. Then inexplicably, it stayed steady. never dropping below 50 degrees for the next 4.5 hours. Never dropping below 50 degrees for the next 4.5 hours, basically through the entire night. He was not outside. He was someplace warmer, like a basement or a garage. Dr. LaPosada confirmed that John O'Keefe did not have hypothermia. No telltale signs, no telltale Wisniewski spots, no frostbite on any extremity. He did not die of hypothermia because he wasn't outside. Dr. Isaac Wolf, Dan Wolf, Elizabeth LaPosada, Judson Welsher, Andrew Rentschler, all agreed. Every expert agreed. This is how John O'Keefe died. A rearward fall from a standing position. What could make you fall straight back like that? Let's just think about that for a second. What could make you fall from a standing position as Judd Welcher just showed us? Standing up, falling straight back. Add a laceration to the right eye consistent with a fist or a punch, and you've got your answer.
Yep.
He certainly didn't sustain that wound on the back of his head by falling backwards onto a lawn. Dr. LaPosada told you that the patterned injury on the back of John's head could only be produced by hitting a hard, ridged, or ledged surface, like a concrete stair or step. What's just through that garage door? Michael Proctor never stepped down in that garage to find out. What a shame.
Because he didn't care.
And look at the arm. Just look at John's arm. You don't need the top experts in the country, but you had them. You don't need the top medical minds on the planet on this issue, but you had them. These are dog bites and scratches. These are animal wounds. Not one witness has been called in their trial. Not one. 8 weeks and counting. Not one witness who actually disputes that John O'Keefe's arm injuries are from a dog. The Commonwealth could not find a single medical expert, a single medical witness who would come in here and tell you those are inconsistent with a dog bite or a scratch. And it's equally clear that there was no collision. Dr. LaPosada told you in probably the clearest voice in the entire trial. You remember her testimony. He didn't get hit by a car, in her words. He just didn't get hit by a car. You remember the question that was posed by Mr. Brennan, did you consider the speed of the vehicle? And she said, speed didn't matter because he didn't get hit by a car. She repeated it 3 times because it's true, not just because she says so, but because the medical evidence proves it. The medical science proves it.
Yep.
There was no collision. Dr. Rentschler told you unequivocally and just as firmly he didn't get hit by a car. The Commonwealth has not met their burden. They cannot meet their burden. The Commonwealth hasn't called a single medical professional, not one, to testify that John's wounds came from being hit by a car. Not Dr. Scorti-Bello, not Dr. Isaac Wolf. Contrast that with the caliber and the quality of the experts who came in here to tell you what is obvious to anyone with common sense. Those wounds on his right arm are from a dog. This was not an oversight by the Commonwealth.
Nope.
It's just that there is no one out there. No matter how big a check you write. I
love that. It doesn't matter how big of a check you write. Aperture, yeah, you can buy them. Pay them $500,000 and you'll get your fake experts. They couldn't find. They searched and searched and searched and searched. They couldn't find a single expert to say, this is not an animal. Dude, this is an animal attack. Like, come on. I can't. I'll give you $1 million to say it wasn't. I can't take your money. I can't say this.
The fact is, this is the central fact in the case. The only fact that matters is literally uncontested by every medical expert. Uncontested, undisputed. There is no evidence that John was hit by a car.
Yep.
None. How much more reasonable doubt could there be?
Right.
This case should be over right now.
Yeah.
Done.
Hopefully it will be.
Because there was no collision. So given all that, how did Karen Reed end up sitting here?
Good question.
Why is she even here? Why is she in that chair? Why is she in this courtroom? There is a reason for that. And it's a reason they don't want to tell you, and it's a reality they don't want to admit to. The reason we're here is because the system, the very system that was meant to protect her, that was meant to protect all of us, that system has failed badly. So now let's discuss the facts that were and were not presented by the Commonwealth in this case. Over the next few minutes, I want to talk about the utter failure of the police to investigate this properly and to investigate this fully. And what you're going to see is that Michael Proctor, the lead investigator for the Commonwealth, did nothing to actually and properly investigate this case. Let's start with the house. That's the most logical place to start. I think you'd agree. Brian Albert's house, where John's body was discovered lifeless in the lawn. A man, a police officer, is found dead on the front lawn, and no one secures the scene. No tape, no preservation of evidence, no crime scene log, no search warrants, no consent searches, no photographs of the house interior. They didn't treat the house as a crime scene, and shamefully, they didn't even treat the yard as a crime scene. The lame excuse offered by retired Lieutenant Gallagher: it was really cold and windy, and I didn't know if there was a crime that had been committed.
What?
What? You didn't know that a crime had potentially been committed?
A dead cop on the lawn?
You have a man laying dead in the yard, and here are the undisputed facts that those officers were confronted with. Black eyes. Obviously, black eyes are consistent with a fight. Bloody nose, also consistent with a fight. Bleeding from the face, consistent with a physical altercation. A cut over the right eye, consistent with a punch. No coat in the freezing cold, not dressed for outside, dressed for inside, and one shoe on. I wonder where the other shoe could be. I don't know, maybe in the house 30 feet away.
Huh? If you're thinking about
And then
that,
you find a broken and shattered drinking glass next to him, the type of glass that you might find, I don't know, let me think about this, in a kitchen, in a house, 30 feet away.
do you see how obvious it all becomes when you just tie it all together? The glass from the house, the shoe, where is it? It's inside the house. The clothes he's wearing, not fit for someone to be outside. He left his coat in the house. His hat was off. Like, it's just mind-boggling, folks. It's just absolutely mind-boggling.
And John's phone was tucked neatly under his back shoulder. Lieutenant Gallagher actually claimed he did not know it was a potential crime that needed investigating.
Ridiculous.
The neighbor across the street, Detective Lieutenant Kelleher, had a ring camera that was pointed at the exact direction where John O'Keefe would have been hit, and nobody bothered to secure it. Nobody bothered to secure it. Nobody even bothered to look at it.
Because they don't care.
Of course this was a potential crime scene. Of course it was. Let's not forget, this was Brian Albert's house, and that comes with privileges.
Oh God. They are special, folks. They're not like you and me. They are special because they are police officers and EMTs. They get special treatment. They get special privileges. Ones that we are not privy to. You can imagine how angry that makes the jury to realize about all of this stuff and to think about it. So, with that, folks, we're going to conclude this video. We're going to resume tomorrow with parts 3 and 4, Saturday, June 14th, and I will see you all there. Bye, everybody.